Hello, everyone. We're going to continue with part two of this special read. So, this is a Harvard Law Review article called Dobbs and Democracy. So, we're going to continue. Political power myopia. The Dobbs majority's opinion's limited view of the direction of democratic change is matched by its exceedingly limited vision of political power. According to the majority, women are not without electoral or political power. Critically, on this conception, political power is reducible to voting and perhaps running for office. But who decides that women have ample political power? It is true, as Justice Alito noted, that when it comes to participation, women today are registered to vote and turn out to vote at higher rates than men. But even putting to one side the significant obstacles women, who are often the principal caregivers in the family, must surmount to actually exercise the franchise, if we use any metrics beyond simply voting to measure democratic participation, the empirical portrait looks decidedly different. When it comes to membership in state and local government, for example, women are grossly underrepresented. Today, women occupy 32.7% of the 7,386 seats in state legislatures. In some states, the number of women serving in the state legislature is far lower. In Mississippi, for instance, where Dobbs arose, the state legislature is composed of 14.4% women. In West Virginia, the number is 11.9%, and in Tennessee, it is 15.2%. This underrepresentation in state legislatures is striking, particularly in view of Justice Alito's suggestion that democratic deliberation of the abortion question should properly be reserved for state legislatures. State and local executive branch offices are even more lopsided. Today, in cities and towns with populations over 30,000, only 25.8% of mayors and comparable local officials are women, and governorships fare still worse. A mere 12 U.S. states and the U.S. territory of Guam have women in the governor's mansion. The composition of the federal legislature is also uneven in terms of gender representation. Just 25 women serve in the United States Senate, and 125 women serve in the United States House of Representatives. These figures represent only about a quarter of each chamber. And notably, the women who do attain seats in the federal legislature tend to be significantly older than their male counterparts. Research suggests that women enter elected office later in life, often after having children or even after their children have left home. In the 116th Congress, for example, the average age for members was 47. By contrast, the average age for female members was 64, nearly 20 years older. The most recent election, post-Dobbs, reflected a narrowing of this gap, with an average age of 46 for Congress's incoming women members, much younger than the average age of women in Congress overall. State legislatures reflect a similar age imbalance in representation, although data here is more dated. In 2001, 39% of male state legislators were under 50, while only 24% of female state legislators were under 50. While 28% of male state senators and 30% of male state representatives entered office when they were 40 years old or younger, the same was true of only 11% of female state senators and 14% of female state representatives. Women are also woefully underrepresented in the ecosystem that surrounds Congress. As scholars have shown, from 2008 to 2015, women accounted for only 37% of the lobbyists in Washington. Women are also much less likely than men to donate to political candidates. In fact, a 2020 study by the Center for American Women and Politics showed that men outdonated women in state legislative elections by a 2-to-1 ratio. Studies confirm these disparities in federal elections, both congressional and presidential. A recent paper analyzing contributions from 1980 to 2008 found that in 1980, women made only a little more than 20% of federal campaign contributions, and that by 2008, the number was still a little less than 37%. Another recent study found an even starker divide in the context of women of color, who accounted for merely 2% of individual contributions to House races in 2010, despite constituting approximately 18% of the population. By any measure, these metrics make plain the enduring disparity in women's political power at both the state and federal levels, and important recent work reveals the impact of women's representation, or more often underrepresentation, on abortion policy. There is a very significant relationship between women's presence in the legislature and the degree of permissiveness of abortion policy, with legislatures that contain higher percentages of women enacting policies that are more protective of abortion access. Further, the court's uncritical account of women's political power is linked to its limited understanding of who comprises the polity. On one level, the court's vision of the polity is limited to those who have managed to overcome state imposed obstacles to voting, obstacles that the court, through many of its voting rights decisions, has credited and blessed. On another level, however, the court's vision of democratic deliberation prioritizes and privileges moments of democratic debate that included only some members of the political community. For example, when the Dobbs majority insisted that Roe interrupted state level debate and deliberation of the abortion issue, it was often referring to mid 20th century debates over whether to repeal or liberalize then extant abortion restrictions. What is missing from the court's account of these debates is the fact that the laws and policies being debated were enacted through democratic processes that were categorically closed to all but white men. That is, they were democratic processes in which the polity affirmatively did not include women and people of color. On this account, the debates that Roe preempted and that the Dobbs majority prioritized and sought to vindicate in returning the abortion issue to the states were debates over whether to retain or liberalize laws enacted under conditions of extreme democratic deficit. And meaningfully, the impulse to tout such laws as reflective of democratic deliberation endures in the aftermath of Dobbs. Consider the recent debates over Wisconsin's 1849 abortion prohibition. This prohibition, which predates the 19th Amendment by 70 years and the Wisconsin Constitution's amendment granting women's suffrage by 85 years, was enacted at a time when women were without formal political power. Despite this demonstrably undemocratic provenance, Republican politicians now argue that post-Dobbs, the state should be permitted to enforce the 1849 law, which remained on the books after Roe in a state of desuetude. And critically, even though women and people of color are eligible to participate, the current debate over whether the law should remain in force is unlikely to produce true democratic deliberation. Wisconsin is subject to one of the worst gerrymanders in the country, meaning that there is virtually no prospect of repealing the 1849 law through ordinary legislative processes. Methodological myopia. Finally, the method the court used in overruling Roe and Casey and concluding that the Constitution does not protect the right to terminate a pregnancy reveals the hollowness of the court's professed commitment to principles of democracy. The court held that when determining whether an unenumerated right is nevertheless a protected liberty, courts must look to history and tradition. In the words of the opinion, guided by the history and tradition that map the essential components of our nation's concept of ordered liberty, we must ask what the 14th Amendment means by the term liberty. Focusing on that question, Justice Alito concluded that in the present case, the clear answer is that the 14th Amendment does not protect the right to an abortion. But on what does the court's history and tradition analysis rely? As the Dobbs majority made clear, its prescribed methodology consisted primarily of examining a slew of mid-19th century statutes. Notably, many of these statutes were enacted during a wave of nativist furor aimed at increasing the birth rate among native-born white women. That is the context in which these statutes were enacted. But more than that, the laws that were central to the majority's conclusion that the 14th Amendment does not protect abortion rights were, every one of them, enacted in an era in which women could not vote, run for political office, or participate in any way as full and equal members of the polity. Apparently oblivious to this democratic deficit, the Dobbs majority compounded it, reaching back still further to cite Sir Matthew Hale, a 17th century barrister and jurist, for the proposition that abortion of a quick child who died in the womb is a great crime and a great misprison. Put differently, the Dobbs majority's method of analysis and interpretation bound the contemporary meaning of the Constitution to a body of law and authority in whose enactment and creation neither women nor people of color played any part, recognizing only those rights already recognized by a ruling minority elite who were chosen to govern through undemocratic or at best partially democratic means. This is a methodological approach that reifies the conditions of democratic deficit, hardly a methodology that values democracy and true democratic engagement. More troublingly, the Dobbs decision failed to grapple with the ways in which withdrawing the abortion right would restrict the full democratic participation and equal citizenship of women. There is a powerful argument that women's full citizenship under the 14th Amendment's Equal Protection Clause, as well as the 19th Amendment's right to vote, requires control over their reproductive lives. The majority's refusal even to grapple seriously with those arguments is further evidence of the opinion's crabbed and thin commitment to democracy. In the initial aftermath of Dobbs, it appears that the public not only does not share the Dobbs majority's substantive views about abortion, it also does not share its cramped vision of democracy. Instead, Dobbs has fueled considerable public interest in state level direct democracy, initiatives, referenda, ballot questions, and similar devices, all of which allow individual voters to directly register their preferences unmediated by other institutions or actors. As we noted earlier, in the wake of Dobbs, direct democracy initiatives have allowed voters to weigh in on the abortion issue at the state level, and in these circumstances, voters have overwhelmingly registered their preferences for reproductive freedom. Indeed, in the post-Dobbs era, every time voters have gone to the polls to vote directly on abortion, they have voted to protect or expand access to abortion. The first such state was Kansas, where in August 2022, a resounding 59% of voters rejected an amendment that would have removed abortion rights protections from the Constitution and allowed state legislators to ban or restrict the procedure. This trend only accelerated during the November 2022 election, when voters in California, Michigan, and Vermont enshrined abortion protections in their state constitutions. California voters added language to their constitution to explicitly guarantee that the state shall not deny or interfere with an individual's reproductive freedom in their most intimate decisions, which includes their fundamental right to choose to have an abortion and their fundamental right to choose or refuse contraceptives. Michigan voters adopted a constitutional amendment guaranteeing abortion rights and reproductive freedom, overriding a 1931 abortion ban that might otherwise have taken effect. And in Vermont, where a 2019 law already guaranteed abortion rights, voters used the referendum process to install an additional layer of protection, enacting Article 22, the Reproductive Liberty Amendment, which broadly guarantees personal and reproductive autonomy unless justified by a compelling state interest. To be sure, direct democracy was not simply a vehicle for expanding reproductive freedom. In various states, voters also went to the polls to register their objections to efforts to limit reproductive rights. Following Kansas's lead, Kentucky voters rejected a constitutional amendment that would have made it harder to challenge abortion restrictions. The amendment sought to direct questions of access to abortion to the state's Republican-controlled legislature and prevent state courts from interpreting the state constitution in favor of abortion rights. In Montana, voters rejected L.R. 131, a ballot initiative that, in circumstances involving unsuccessful abortion procedures, declared those fetuses legal persons with rights to medical care. The proposed initiative also required doctors to provide resuscitative care for newborns with a fatal prognosis, even when no amount of medical care would save them, and despite the wishes of parents. Widely viewed as an effort to stigmatize abortion and constitutionalize fetal personhood, the measure lost by a vote of 53% to 47%. Given the robust interest in direct democracy in the post-Dobbs era, it is notable that we also have seen state actors, in particular state legislatures, laboring mightily to limit access to such initiatives. For example, in Ohio, lawmakers convened a special election to raise the threshold for using ballot initiatives as a means of amending the state constitution from 50% to 60%. The proposal, which was broadly understood as a means of thwarting efforts to amend Ohio's constitution to protect abortion rights, was roundly defeated in August 2023. The Arkansas legislature was more successful, tripling the number of counties from which signatures must be collected in order to qualify an initiative for the ballot, a move that was widely regarded as a hedge against efforts aimed at protecting and expanding reproductive rights in the state. Likewise, in Mississippi, the state legislature has taken steps to prohibit ballot and voter initiatives in the substantive area of reproductive rights. Similar measures are being pursued in North Dakota and Missouri. These dynamics are striking and worthy of further scholarly attention. We will only note here that the court itself has effectively underwritten these efforts to thwart direct democracy. As we discuss in the following part In recent years, the court has issued a raft of decisions that distort and alter the electoral landscape, making the prospect of true democratic deliberation elusive, to the extent that voters have been able to deploy direct democracy initiatives to articulate their preference for reproductive freedom. It has been in spite of, not because of, the Roberts Court's jurisprudence of democracy. The Court and Democracy, Rhetoric and Reality. Considering the Dobbs opinion from these perspectives reveals the shallow nature, indeed the cynicism, of the court's paeans to democracy. Dobbs' hollow commitment to democracy is even more pronounced when considered alongside the court's active interventions to distort and disrupt the functioning of the electoral process. Indeed, Dobbs arrives in the wake of a series of high court decisions that, taken together, have made our democracy decidedly less representative and less democratic. These cases and their evident hostility to voting rights take on new salience in the context of the Dobbs Court's insistence on returning the question of abortion to non-court entities for resolution. We hasten to note, as we did in the preceding part, that our discussion here is by design limited. We do not consider democracy in its full scope and breadth, but rather we mostly limit our discussion to the electoral process. The part that follows turns more directly to what Dobbs tells us about this court's role in our democracy. This part begins with the court's recent jurisprudence on various aspects of the democratic process. Although the cases involve discrete legal questions, they are remarkably similar in valence and outcome, invariably erecting obstacles to participation or invalidating efforts of state and federal lawmakers to facilitate participation and access to the franchise. After considering the court's cases dealing explicitly with the infrastructure of democracy, we then examine a series of cases in which the court, or some of its members, as in Dobbs, prioritized democratic deliberation ahead of judicial intervention. As we note, in these moments where the court prioritizes democratic deliberation, it is also avoiding a judicial settlement that would preserve and protect the interests of less politically powerful minority groups. The infrastructure of democracy. The topic of the court's democracy-undermining interventions is vast and well canvassed, so our discussion here does not purport to be comprehensive, but we offer examples of the court's moves to limit the exercise of the franchise and the prospect of an inclusive democracy. Taken together, these cases have produced a landscape in which any post-Dobbs deliberation will happen under conditions of severe democratic deficit. First, in a series of cases, the court has hobbled the Voting Rights Act, VRA, a federal statute enacted in 1965 with the explicit purpose of ending racial discrimination in voting. The VRA, in the words of Justice Kagan, marries two great ideals, democracy and racial equality, and it dedicates our country to carrying them out. Despite these lofty aspirations, again and again, the Roberts Court has undermined these ideals and the landmark legislation intended to enshrine them as law. In 2013, a 5-4 court in Shelby County v. Holder struck down a provision of the law that required states and localities with especially egregious histories of race discrimination in voting to obtain pre-approval from a federal court or the Department of Justice before implementing any change to their voting policies or procedures. In invalidating the pre-clearance formula, the court gave short shrift to the act's reauthorization by overwhelming congressional majorities and the extensive legislative record of the continued disenfranchisement of minority voters compiled in the course of the reauthorization. In 2021, in Brnovich v. Democratic National Committee, the court continued its assault on the VRA, narrowly interpreting Section 2 of the statute to limit the scope of cases in which litigants can successfully challenge suppressive voting policies. As commentators have noted, the court's decision in Brnovich rendered meaningful enforcement of the VRA's prohibition on discriminatory voting laws exceedingly difficult. Although in the 2023 case of Allen v. Milligan, the court maintained a meaningful role for Section 2 in the context of racial gerrymandering. In addition to limiting the reach of the VRA, the court, in 2019's Rucho v. Common Cause, announced that federal courts will not enforce any limits on partisan gerrymandering, a process that allows self-interested politicians to draw legislative district lines in ways that ensure a particular party's continued hold on power. The court's dramatic 2019 announcement that challenges to political gerrymanders represent non-justiciable political questions followed a series of cases over several decades in which the court had signaled serious concerns about the constitutionality of excessive partisan gerrymanders. In 1973, the court noted in passing that a districting plan may create multi-member districts perfectly acceptable under equal population standards, but invidiously discriminatory because they are employed to minimize or cancel out the voting strength of racial or political elements of the voting population. In 1986, a majority of the court held that challenges to partisan gerrymanders were justiciable, but no majority coalesced around a methodology that courts could deploy to resolve such challenges. In 2004 and 2006, the court again acknowledged the serious constitutional concerns that excessive partisan gerrymanders posed, but again it could not reach consensus about how to craft a manageable standard for policing the practice. But in Rucho, a 5-4 court held that while excessive partisan gerrymanders are incompatible with democratic principles, leading to results that reasonably seem unjust, federal courts are nevertheless powerless to stop them. According to the court, because challenges to partisan gerrymanders present political questions, challenges to such efforts to distort the democratic process are better left to other institutions, including state politicians and legislatures, the very actors who stand to benefit from these distortions. In the wake of Rucho, state legislators, apparently emboldened by the knowledge that federal courts would not enforce any limits on partisan gerrymanders, have engaged in ever more aggressive gerrymanders. Wisconsin supplies a particularly egregious recent example of the practice. In 2022, the Democratic governor was reelected by a margin of 51.2% to 47.8% statewide, and a Democrat also won the statewide race for Attorney General. Yet one of the most aggressively partisan legislative maps in the country meant that Republicans held approximately 64% of seats in the state assembly and 67% of seats in the state senate. Following Rucho, some states have tried to address partisan gerrymandering, either by creating independent districting commissions to draw legislative maps, or through state court litigation in which state Supreme Courts are asked to determine whether partisan gerrymanders violate state constitutional guarantees. These outcomes proceed directly from the court's directive in Rucho, which emphasized at length that the federal court's inability to address partisan gerrymandering did not foreclose anti-gerrymandering efforts undertaken in other venues, including state redistricting commissions and state courts. And yet, there is every reason to worry about how these modest interventions might fare before this court. In 2015, Chief Justice Roberts insisted in a dissent that independent redistricting commissions were unconstitutional, and given intervening personnel changes that have occurred at the court, there may, in the future, be sufficient votes to enshrine Chief Justice Roberts' view into law. And although the court in the 2023 case Moore v. Harper rejected a strong form of the so-called independent state legislature theory, which would have prevented state courts from ever enforcing state constitutional limits on gerrymandering, the Moore opinion emphasized that federal courts could play a role in reviewing state court interpretations of their own state constitutions. Such a view could further undermine state-level efforts to combat gerrymandering. The court's decisions in recent decades have also dramatically altered the financial landscape in which elections are conducted. In 2010, the court in Citizens United v. FEC opened the floodgates to corporate spending in federal elections, allowing moneyed interests to dominate political campaigns. Its decision striking down long-standing limits on corporate spending in federal elections fundamentally transformed the campaign finance landscape, but the impact of the opinion and its logic have extended well beyond the particular corporate spending provision at issue in the case, dramatically limiting lawmakers' ability to enact all manner of reforms designed to combat both corruption and the appearance of corruption in campaigns for office. To the extent that federal legislation aims to ensure political participation, the court's decisions have eroded such protections. In 2018's Husted v. A. Philip Randolph Institute, the court voted 5-4 to allow states to purge voters for failing to vote, notwithstanding a provision of federal law that appears to limit states' authority to do just that. In Husted, The court found that Ohio could remove eligible voters from voting rolls, where such voters had not voted for 2 years, had failed to return an official postcard, and had not voted for another 4 years after failing to submit the postcard. The court's decision in Husted put a significant percentage of Ohio voters, really voters everywhere, at risk of being purged from voter rolls for sitting out a few election cycles. Husted is concerning in its own right. It is also doubly concerning because it suggests that the court will credulously accept even unsupported claims of voter fraud or the need for deterrence in defense of ever more burdensome restrictions on the right to vote. Consider next the court's role in blessing the voter ID requirements that have gone into effect in many states and whose ostensible predicate, preventing fraud in voting, has been squarely repudiated in the years since the court allowed states to enforce such requirements. In a case decided in 2008, Crawford v. Marion County Election Board, the court approved an Indian voter identification law and in so doing, credited state representations that the law was an effort to combat in person voting fraud. Even in 2008, the evidence that such fraud was a genuine problem was exceedingly thin, and the intervening years have further eroded any plausible claims of significant in person fraud. And yet, since Crawford was decided, many states have implemented and enforced voter ID requirements. Some lower courts have invalidated such laws, but they remain in force in many states. And although research suggests that restrictive voter ID laws often create sufficient political mobilization to offset any significant impact on election outcomes, it is also clear that the burden of these laws falls disproportionately on low income voters, voters of color, and the youngest and oldest voters. Such laws, then, undermine basic notions of political equality, even if they do not always impact election results. The court's pandemic voting cases are also a striking display of the court's neglect of free and open access to the franchise. During the spring, summer, and fall of 2020, as the COVID 19 pandemic swept the country, local election administrators in some states took steps to facilitate early and absentee voting to allow individuals to vote safely in the period before vaccines were widely available. In decision after decision, the court, by the narrowest of margins, voted to prevent state officials and state and federal judges from taking steps to facilitate voting, relying largely on an underdefined principle that voting rules should not be changed close in time to elections. These interventions included the court itself introducing election eve changes into state voting procedures. For example, in Republican National Committee v. Democratic National Committee, the court intervened the day before an election to stay a district court order that, responding to concerns regarding pandemic related postal delays and potential widespread disenfranchisement, had extended Wisconsin's absentee ballot receipt deadline. The Wisconsin stay was accompanied by a short per curiam opinion, but in other cases in the same pre election period, the Supreme Court intervened without explanation to reinstate restrictive voting rules that had been invalidated in reasoned decisions by lower federal courts. In one particularly egregious case out of Alabama, the court overruled the appellate court, which had upheld a district court order enjoining the state's ban of curbside voting during the pandemic. In that case, the district court reasoned that such a restriction violated the Constitution and the Americans with Disabilities Act of 1990. Although the district court had enjoined the state's prohibition in a lengthy and carefully reasoned written opinion following an 11-day trial, the Supreme Court stayed the district court's injunction without an opinion explaining its reasoning, and less than 2 weeks before the election. Taken together, these cases make clear that the court does not see its task as facilitating democratic participation. In fact, the Roberts Court has never invalidated a state or federal law on the grounds that the challenged law impermissibly undermined or interfered with the right to vote. Where it has invalidated election related laws, it has been on the grounds that they violate the speech rights of campaign donors or the rights of states in conducting elections, but never on the ground that such restrictions interfere with the right to vote, a right the court once described as preservative of all rights. Professor Nicholas Stephanopoulos has referred to the Roberts Court's destructive tendency in cases involving the law of democracy as an anti-Carolyn impulse. The Carolyn products view refracted through refracted through John Hart Eli's Democracy and Distrust, understood the judicial role as bolstering or supporting the infrastructure of democracy, not dismantling it. Vigorous judicial review was legitimate, even where it invalidated the actions of elected officials, if it was undertaken to protect discrete and insular minorities from the vicissitudes of the majority or to preserve access to democratic participation. But viewing the Roberts Court's many interventions in this sphere in tandem, it is clear that this is a court that no longer understands itself as largely or primarily functioning to facilitate the exercise of meaningful democracy in these ways. Rather, in many instances, it appears to be actively working to undermine these goals. Invoking democracy in other contexts. As we showed in the preceding section, the court has done more than perhaps any other institution to disrupt the electoral landscape, making it harder for individuals to register their preferences in majoritarian politics. It is therefore quite striking, and likely no accident, that the court consigned the abortion question to the democratic process at this moment of all moments. In this section, we canvass cases where members of the court have demonstrated enthusiasm for using majoritarian processes to resolve questions that implicate the welfare of discrete and insular minorities. While minority groups often experience greater difficulty vindicating their interests in the political process, in these cases, such concerns do not appear to loom large in the justices' deliberations. This section identifies a number of circumstances and situations, in addition to abortion, in which some of the justices' enthusiasm for abstract conceptions of democracy is quite pronounced, and in which their professed interest in preserving democratic deliberation is especially robust. In these contexts, members of the court forcefully articulate an understanding of the judicial role that involves dispatching contested questions to be resolved through the mechanisms of democratic engagement and deliberation, even in circumstances where other important constitutional values are at stake. Sex discrimination. Decided in the same year as Roe v. Wade, the facts and disposition of Frontiero v. Richardson are well known to students of constitutional law. Sharon Frontiero, a lieutenant in the United States Air Force, sought and was denied dependent benefits for her husband, Joseph. The government conceded that although such benefits would automatically have been granted with respect to the wife of a male member of the uniformed services, Frontiero's claim of dependent benefits for her spouse was denied because she failed to demonstrate that her husband was dependent on her for more than one half of his support. The government conceded that the differential treatment served no purpose other than mere administrative convenience in the processing of dependent benefits. In defense of the policy, the government asserted that, as an empirical matter, wives in our society frequently are dependent upon their husbands, while husbands rarely are dependent upon their wives. A majority of the court, however, disagreed with the government's logic. By an 8-1 vote, the court invalidated the sex-based preference. But although 8 members of the court were united in invalidating the policy, they could not agree on the appropriate standard of review for sex-based classifications. Writing for a plurality of 4 justices, Justice Brennan maintained that classifications based upon sex, like classifications based upon race, alienage, or national origin, are inherently suspect and must therefore be subjected to strict judicial scrutiny. As support for this position, Justice Brennan noted that, like recognized suspect criteria, the sex characteristic frequently bears no relation to ability to perform or contribute to society. Moreover, other constitutional actors seemed to agree. Justice Brennan pointed to recent congressional actions, the enactment of Title VII of the Civil Rights Act of 1964 and the Equal Pay Act of 1963, both of which prohibited sex-based discrimination, and the recent submission of the Equal Rights Amendment, ERA, to the states for ratification, as evidence that Congress itself has concluded that classifications based upon sex are inherently invidious. This conclusion of a co-equal branch of government is not without significance, Justice Brennan intoned. Justice Powell, who authored an opinion concurring in the judgment that Chief Justice Berger and Justice Blackmun joined, also found the submission of the ERA to state legislatures for ratification to be a compelling development. However, unlike Justice Brennan, who saw Congress's approval of the ERA as a signal of its assent to treating sex-based discrimination as on par with racial discrimination, Justice Powell understood the ERA's progress from the federal legislature to state legislatures as a sign of ongoing democratic deliberation on the question of how to deal with sex-based discrimination. If the court intervened, as the plurality wished, to subject sex based classifications to strict scrutiny, it would be acting prematurely and unnecessarily to preempt by judicial action a major political decision which is currently in process of resolution. To be sure, Justice Powell allowed there are times when the court cannot avoid a constitutional decision on issues which normally should be resolved by the elected representatives of the people. But this was not one of those moments where the court was obliged to weigh in. Democratic institutions are weakened, and confidence in the restraint of the court is impaired when we appear unnecessarily to decide sensitive issues of broad social and political importance at the very time they are under consideration within the prescribed constitutional processes. Justice Powell's faith in the ERA and state legislatures was perhaps misplaced. Although Congress enacted the ERA and submitted it to the state legislatures for ratification, the amendment's once rosy prospects soon dimmed. Missouri housewife Phyllis Schlafly launched Stop ERA, a campaign that decried the loss of the right to be a housewife and the material benefits of that status, while also connecting the ERA to support for abortion, gay rights, and civil rights more generally. In the end, Schlafly's Stop ERA campaign was as good as its word. As the ratification deadline closed, the ERA was narrowly defeated, just 3 states shy of the number required for ratification, 38. As democratic deliberation proved unavailing in the effort to provide robust protection against sex-based classifications, so too were the courts an uneven guarantor of women's rights. In 1976, the court eventually settled on intermediate scrutiny as the appropriate standard of review for sex based classifications, permitting the government to distinguish on the basis of sex so long as the classification was substantially related to an important government interest. Under this standard, which is less rigorous than the strict scrutiny standard considered in Frontiero, the court has upheld a range of sex based classifications, including laws that preclude women from the draft, and make it easier for mothers to transmit citizenship to children born out of wedlock in foreign countries. To be sure, the court's jurisprudence on sex discrimination did not end with Frontiero, or with Justice Powell's confident assurances that the political process would resolve the issue once and for all. Indeed, the court, over a series of decisions that includes United States v. Virginia, Nevada Department of Human Resources v. Hibbs, and Sessions v. Morales-Santana, went beyond the tentative protections for sex equality first identified in Frontiero. Given these developments, the Dobbs majority's breezy assurances that a woman's right to choose an abortion should be consigned to majoritarian politics threatens a return to the logic of Justice Powell's concurrence. LGBTQ rights. The domain of LGBTQ civil rights has also been an arena in which the court's deliberations have evinced the tension between judicial protection for minorities and the prospect of preserving opportunities for democratic deliberation. To be sure, in these cases, the court, with narrow majorities, has intervened to protect LGBTQ civil rights, but doing so has often prompted vigorous dissents that focus on judicial restraint as a means of preserving opportunities for democratic debate on fraught issues. In this regard, these dissents often mirror, and in some cases directly invoke, critiques of Roe and the narrative of disrupted democratic deliberation that we earlier discussed. The court's decisions in Romer v. Evans and Lawrence v. Texas are exemplary of this impulse. In Romer, the court invalidated Amendment 2, a Colorado voter referendum that amended the state constitution to prohibit any state recognition of and protection for homosexual, lesbian, or bisexual orientation. In a 6-3 decision, the court struck down the amendment on the ground that it reflected impermissible animus toward the class it affected and lacked a rational relationship to legitimate state interests. In a stinging dissent, Justice Scalia emphasized that the challenged amendment was an expression of the popular will, the result of ongoing statewide deliberation on the issue of gay rights. Indeed, by the time Coloradans were asked to vote on Amendment 2, 3 Colorado cities, Aspen, Boulder, and Denver, had enacted ordinances that listed sexual orientation as an impermissible ground for discrimination. and the governor had signed an executive order endorsing diversity and denouncing discrimination in any form, and directing state agency heads to ensure non discrimination in hiring and promotion based on, among other things, sexual orientation. These successes, Justice Scalia maintained, were the result of democracy working. Without judicial intervention to secure their rights, gay Coloradans had engaged in debate and persuaded their fellow citizens to confer civil rights protections through legislative and executive action. On this logic, Amendment 2 was merely further evidence of democracy at work. According to Justice Scalia, the challenged amendment reflected lawful democratic countermeasures to these gay rights successes, and thus was merely an iteration of the democratic process, a process that the court, through its invalidation of Amendment 2, disrupted. And critically, on Justice Scalia's view, the court's decision was doubly disruptive. Not only had the majority foreclosed the ongoing statewide debate on the question of gay rights, but it also did so by rendering seemingly tolerant Coloradans who wished to express their preferences for traditional attitudes through the political process akin to racial and religious bigots. Justice Scalia would elaborate these themes in subsequent cases concerning gay rights. 7 years later, the court issued a 6-3 decision in Lawrence v. Texas, striking down a Texas anti-sodomy law on the ground that the right to liberty under the Due Process Clause gives gay individuals the full right to engage in their conduct without intervention of the government. In so doing, the Lawrence Court overruled an earlier precedent, Bowers v. Hardwick, on the ground that it overlooked, among other things, changing attitudes regarding homosexuality. In particular, the Lawrence majority emphasized the repeal or destitute of criminal laws prohibiting homosexual conduct, as well as other nations' efforts to affirm the protected right of homosexual adults to engage in intimate consensual conduct. To be sure, the Lawrence majority did not frame its logic explicitly in the language of democracy and democratic deliberation, but it is worth observing that these nods to non-enforcement and shifting attitudes implicitly preempted objections that, in decriminalizing sodomy, the majority was thwarting the will of the people and their elected representatives. But even as the Lawrence majority sought to frame its decision as consistent with the popular will, the dissenting justices insisted that the court's intervention had displaced legitimate democratic reform on the question of same sex sodomy. In a brief dissent that echoed Justice Stewart's dissent in 1965's Griswold v. Connecticut, Justice Thomas pronounced the challenged Texas law a waste of valuable law enforcement resources, but insisted that legislative repeal, rather than judicial declaration of a constitutional right, was the proper way to deal with this uncommonly silly law. Justice Scalia, who authored the principal dissent, took issue with the majority's overruling of Bowers. He drew a direct comparison between Lawrence and Roe, which 4 of the justices in the Lawrence majority had upheld in Planned Parenthood v. Casey. But as important, to Justice Scalia as the majority's casual dismissal of a 17-year-old precedent was its resolution of an issue that was better suited to democratic deliberation. The court, Justice Scalia inveighed, has taken sides in the culture war, abandoning its constitutional role as neutral observer, ensuring that the rules of democratic engagement are observed. Social acceptance of homosexuality was not as settled as the Lawrence majority claimed. Instead, Justice Scalia observed, it was a topic of considerable debate, with many Americans harboring reservations about the prospect of gay business partners, scoutmasters, teachers, and tenants. Their efforts to protect themselves and their families from a lifestyle that they believed to be immoral and destructive were evidence of continued debate, a debate that the court had again short-circuited. Perhaps mindful of the Romer majority's logic, Justice Scalia insisted that his views were not born of animus against gay people, but rather reflected a sincere commitment to the judicial role. As he explained, I have nothing against homosexuals, or any other group, promoting their agenda through normal democratic means. And again, he reiterated that homosexuals have achieved some success in persuading fellow citizens of the rightness of their cause. But, Justice Scalia continued, persuading one's fellow citizens is one thing, and imposing one's views in absence of democratic majority will is something else. The challenged Texas anti-sodomy law was well within the range of traditional democratic action, and the people's hand should not be stayed through the invention of a brand new constitutional right by a court that is impatient of democratic change. Justice Scalia's objections to the decriminalization of sodomy by judicial fiat migrated easily to the court's consideration of a right to same-sex marriage. In United States v. Windsor, a 2013 decision invalidating Section 3 of the Defense of Marriage Act, Justice Scalia reprised his concerns regarding judicial settlement of a contentious social issue. But notably, he was not alone in appealing to democracy. The Windsor majority also invoked democratic deliberation and the will of the people in striking down DOMA. According to Justice Kennedy, who wrote for the majority, after a statewide deliberative process that enabled its citizens to discuss and weigh arguments for and against same sex marriage, New York acted to enlarge the definition of marriage to correct what its citizens and elected representatives perceived to be an injustice that they had not earlier known or understood. On this account, DOMA frustrated that objective by imposing a system-wide federal definition of marriage. More troublingly, DOMA sought to injure the very class New York sought to protect, expressing moral disapproval of homosexuality and treating state-recognized same-sex unions as second-class marriages for purposes of federal law. Indifferent to the majority's attempt to cloak itself in the mantle of democracy, Justice Scalia, in dissent, elaborated on themes honed earlier in Romer and Lawrence. In particular, Justice Scalia objected to the majority's conclusion that DOMA evinced unconstitutional animus toward same-sex couples. On his account, if the question was the disruption and frustration of democratic debate, the problem did not lie with DOMA's articulation of a federal definition of marriage, but rather with the majority's animus rhetoric, which formally declared anyone opposed to same-sex marriage an enemy of human decency. Since DOMA's passage, Justice Scalia mused, citizens on all sides of the question have seen victories and they have seen defeats. There have been plebiscites, legislation, persuasion, and loud voices. In other words, democracy. The majority's rhetoric, equating a preference for the traditional understanding of marriage with the purpose and effect to disparage and to injure the personhood and dignity of same-sex couples, threatened an end to a theretofore productive debate by casting those who objected to same-sex marriage as bigots. In this regard, although the Windsor majority explicitly sought to vindicate state-level deliberation on same-sex marriage, Justice Scalia now insisted that the decision was effectively a judicial distortion of our society's debate over same-sex marriage, that would, as the debate over marriage equality intensified, arm well every challenger to a state law restricting marriage to its traditional definition. Put differently, challenging discrimination as discrimination undermined democracy. 2 years later, in Obergefell v. Hodges, a 5-4 decision legalizing same-sex marriage, Justice Scalia, now joined by the Chief Justice and Justice Thomas and Alito, again raised the issue of democratic deliberation and emphasized the majority's disruption of ongoing debate at the state level over whether to expand civil marriage to include same-sex couples. Both Chief Justice Roberts and Justice Alito emphasized the linkages between democratic deliberation, enumerated rights, and constitutional protection. As the Chief Justice mused, because our Constitution does not enact any one theory of marriage, the question of whether to expand marriage to include same-sex couples or to retain the historic definition rested with the people. Like Chief Justice Roberts, Justice Alito bemoaned federal court intervention in this ongoing debate about whether states should recognize same-sex marriage. On this account, the majority's decision that legalized same-sex marriage was not a vindication of a civil right, but an expression of judicial imperialism. Justice Thomas and Scalia agreed, particularly on the point of the Obergefell Court's disruption of ongoing state-level debate about same-sex marriage rights. According to Justice Thomas, the definition of marriage had been the subject of heated debate in the states, with 35 states having put the question to the people themselves. Likewise, Justice Scalia extolled the public debate over same-sex marriage as democracy at its best, that is, until the courts put a stop to it. Perhaps anticipating these objections, the Obergefell majority underscored its commitment to a limited judicial role, one that imagined the courts intervening in order to protect minorities against the vicissitudes of majority will. Under the Constitution, the majority allowed democracy is the appropriate process for change, so long as that process does not abridge fundamental rights. The people's right to debate and determine fraught issues could not eclipse the protection of fundamental rights, particularly for those groups who could not vindicate their interests in the political process. Thus, when the rights of persons are violated, the Constitution requires redress by the courts, notwithstanding the more general value of democratic decision-making. Indeed, in terms that evoke the logic of Carolyn Product's footnote 4, the majority reasoned that this is why fundamental rights may not be submitted to vote. They depend on the outcome of no elections. These appeals to other constitutional commitments were ignored. However, as the dissenters doubled down on the view that judicial recognition of same sex marriage deprived the polity of the opportunity to debate and determine another contentious question. Indeed, according to Justice Thomas, the majority's recognition of same sex marriage rights not only deprived the people of a voice in the debate, but also deprived them of the established process for protecting their liberty from arbitrary interference. On this account, vindicating the liberty of same sex couples required depriving the people of the opportunity to protect their liberties through the process of representative government at the state level. Affirmative action and the political process doctrine. As the previous sections make clear, the issue of democratic deliberation often has surfaced in cases directly contesting the scope and substance of individual rights. However, it has also surfaced in cases that more generally contest the fitness of the political process for resolving disputes involving individual rights. The court's disposition of 2014's Shoot v. Coalition to Defend Affirmative Action, Integration and Immigrant Rights, and Fight for Equality by Any Means Necessary, BAM, is exemplary of this impulse. Shoot concerned Proposal 2, a Michigan voter referendum enacted in the wake of Grutter v. Bollinger, a 2003 Supreme Court decision that upheld the limited use of race-conscious admissions policies. Proposal 2 amended the state constitution to prohibit public universities from using race-conscious affirmative action measures. The plaintiffs, most notably the Coalition to Defend Affirmative Action by Any Means Necessary, BAM, argued that the referendum violated the political process doctrine. First announced in the 1969 case Hunter v. Erickson and elaborated in Washington v. Seattle School District No. 1, the political process doctrine provides that citizens cannot vote to establish special procedures that create hurdles for minorities who seek to advance their interests through the political process. Although the doctrine was announced and elaborated in the Hunter-Seattle line of cases, its roots lie in Carolyn Product's footnote 4, which elaborated the view that more searching judicial scrutiny and intervention may be required in circumstances where state action is the product of prejudice against discrete and insular minorities, which tends seriously to curtail the operation of those political processes ordinarily to be relied upon to protect minorities. Indeed, in invalidating a statewide voter initiative designed to terminate the use of mandatory busing for purposes of racial integration, the court in Seattle relied explicitly on Carolyn Product's logic. As the Seattle court explained, where the state's allocation of power places unusual burdens on the ability of racial groups to enact legislation specifically designed to overcome the special condition of prejudice, the government action seriously curtails the operation of those political processes, ordinarily to be relied upon to protect minorities, thereby triggering the judiciary's special role in safeguarding the interests of those groups that are relegated to such a position of political powerlessness as to command extraordinary protection from the majoritarian political process. As Ban explained, Proposal 2 bore the hallmarks of the actions invalidated in Hunter and Seattle. The voter referendum was proposed to eliminate the use of race-conscious admissions policies, and to make the restoration of such measures subject to the political process going forward. If Proposal 2 passed, those seeking to restore race-conscious admissions policies would first have to persuade the state's regents of the desirability of doing so, and then would have to secure the hundreds of thousands of signatures needed to place the issue on the ballot and fund a costly campaign to convince Michigan's voters, all with no guarantee of success. And critically, those seeking admissions preferences on other grounds, like geographic diversity, encountered a less arduous process, simply persuading the state regents to adopt their position. They were not required, as proponents of race-based measures were in the wake of Proposal 2, to advance their cause through multiple iterations of majoritarian politics. In this regard, the challengers argued Proposal 2 functioned in much the same way as did the policies invalidated in Hunter and Seattle. Using a voter initiative and majority rule, Proposal 2 disrupted the landscape to make it more difficult for those who would benefit from race-conscious admissions, racial minorities, to advance their interests. A plurality of the Supreme Court, however, disagreed, and in so doing, significantly narrowed the scope and substance of the political process doctrine. Writing for the plurality, Justice Kennedy disavowed a broad reading of Seattle and the application of strict scrutiny to any state action with a racial focus that makes it more difficult for certain racial minorities than for other groups to vindicate their interests in the political process. Rather than determine whether the challenged state action was racially focused, an inquiry that might promote reliance on demeaning stereotypes and fuel racial antagonisms and conflict, the plurality instead held that strict scrutiny should apply only in circumstances where the action caused or risked injury on the basis of race. With this intent inflected standard in mind, the plurality concluded that no authority in the Constitution or in the court's precedents allowed courts to override Michigan's voters' decision regarding race conscious admissions. In a searing dissent defending the now hobbled political process doctrine, Justice Sotomayor recounted a long history in which majorities had distorted the political process in order to suppress minority votes, prevent minorities from holding office, and thwart desegregation efforts. In circumstances where the majority exploited its political might to suppress the interests of minority groups, the courts were obliged to intervene. The political process doctrine, Justice Sotomayor maintained, was a central check on majority rule, one that ensured that majorities and minorities alike played by the same rules in the political process. In hobbling the political process doctrine, the Shute plurality, she argued, dismantled the long held view that a majority may not reconfigure the existing political process in a manner that creates a two-tier system of political change, subjecting laws designed to protect or benefit discrete and insular minorities to a more burdensome political process than all other laws. In terms that presaged the Dobbs majority's Democratic myopia, Justice Sotomayor chided the Shute plurality for concluding that the court's role in ensuring political participation was limited to securing minority access to the franchise. Not so, she countered. In addition to ensuring access to the franchise, the court was obliged to vigilantly police the political process to ensure that the majority did not use other methods to prevent minority groups from partaking in that process on equal footing. As the foregoing sections suggest, Dobbs is not the only instance where the court, or at least some members of the court, has sought to prioritize democratic deliberation and democracy at the expense of individual rights. Indeed, as Frontiero and Shute make clear, even in those circumstances where there is a recognized commitment to individual rights, the court may nonetheless decline to intervene to protect the interests of certain constituencies if it concludes that those interests might also be secured through democratic deliberation that is already occurring, or if those interests run counter to outcomes that might be achieved in the political process. And meaningfully, many of the circumstances in which the court has prioritized preserving opportunities for democratic deliberation are situations in which minority groups are seeking judicial recognition or confirmation of their civil rights. To be sure, the cases canvassed here do not always involve a majority of the court. In Frontiero, only Justice Powell appealed to democratic deliberation. In the gay rights cases, a durable minority of the court underscored the importance of popular debate in the context of fraught social issues. But even if these dissenting voices comprised only a minority of earlier courts, Dobbs made clear that the mathematics have shifted considerably. Voices once in dissent now likely reflect a majority, or supermajority, of the court. With these dynamics in mind, it is worth focusing greater attention on the degree to which the pivot to democratic debate and the prospect of resolving fraught issues through the political process intersects with the interests of underrepresented minority groups who, historically, have struggled to vindicate their interests in majoritarian politics. Dobbs, Democracy, and Distrust. In his Yale Law Review, Yale Law in his Yale Law Journal essay, The Wages of Crying Wolf, a comment on Roe v. Wade, Eli famously denounced the 1973 decision as not constitutional law, with almost no sense of an obligation to try to be. Eli would go on to author Democracy and Distrust, a theory of judicial review, the 1980 book that is among the most influential texts in constitutional law. If Wages focused principally on the Roe Court's substantive error in announcing a right to abortion, Democracy and Distrust addressed broader themes: the defense of judicial review, where it was exercised for the purpose of ensuring or enhancing democratic participation and engagement, responding to scholars like Professor Alex M. Bickel and Professor Herbert Wechsler, who questioned judicial review as counter-majoritarian and inconsistent with principles of judicial neutrality. Eli sought to reconcile constitutional adjudication with representative democracy by defending exercises of judicial review that sought to vindicate the political process and reinforce representation. Given Eli's interest in preserving democracy and enhancing the conditions of democratic deliberation, it is curious, or perhaps telling, that the Dobbs majority disregarded democracy and distrust, focusing almost entirely on wages, Eli's critique of Roe. But even if it is not explicitly discussed, Eli's political process defense of judicial review as a means of preserving democracy and fostering democratic deliberation shadows every corner of the Dobbs majority opinion. When he published Democracy and Distrust in 1980, Eli sought to defend the Warren Court and its decisions against charges of judicial activism and overreach. His account of political process theory did so by framing the Warren Court's most controversial decisions on issues of malapportionment and voting rights as efforts to bolster and advance democracy. Drawing on Carolyn Product's footnote 4 and its articulation of the circumstances in which searching judicial review was warranted, Eli offered a defense of the Warren Court's decisions as efforts to enhance and preserve the political process and to ensure the rights and thus the political participation of discrete and insular minorities who would otherwise find themselves at the mercy of the majority. Unlike Wages, Democracy and Distrust was not singularly focused on Roe. Nevertheless, Eli's antipathy for the decision was as evident in the book as it was in the 1973 article. In Democracy and Distrust, Eli associated Roe with Lochner, describing both as exemplars of the court's sporadic ventures into across-the-board substantive review of legislative action, and describing such ventures as probably wrong. Dobbs, then, could certainly have located support for its result in Democracy and Distrust. So, what explains the oversight? Perhaps the explanation can be found in a deeper analysis than Eli presented, or could perceive, of the actual interaction between reproductive freedom and democracy. In a recent article, Professors Douglas Najami and Reva Siegel challenged Eli's assessment of substantive due process as democracy diminishing, forcefully arguing that Eli's account of political process theory did not fully appreciate or even acknowledge the degree to which judicial deliberation and recognition of substantive due process rights actually responded to democratic engagement on issues of sex and sexuality. As they explain, judicial review of issues like abortion, sexual intimacy, and same sex marriage did not always lead to recognition of rights, but it occurred in the context of growing engagement with these questions in a wide variety of fora: grassroots organizing, state court litigation, and political mobilization. As Najam and Siegel argue, Eli's account of substantive due process not only fails to appreciate the democracy enhancing potential of judicial review of these issues, but it also fails to appreciate the degree to which recognition of substantive due process rights has enhanced equality values by allowing certain constituencies to participate in the polity as equal citizens. Or perhaps the Dobbs majority's interest in wages, as opposed to democracy and distrust, simply served other rhetorical and discursive purposes in Dobbs. Just as Eli sought to insulate the Warren Court from claims of judicial imperialism by recasting its decisions as democracy enhancing, the Dobbs majority sought to insulate its overruling of Roe and Casey from charges of judicial imperialism by recasting it as an effort to restore and preserve democracy. Certainly, there is considerable rhetorical power in this framing. The invocation of democracy allowed the majority to claim that it had not taken sides in the culture war, but rather merely performed its constitutional role as a neutral observer, ensuring that the democratic rules of engagement are observed. But it is not just that an appeal to democracy paradoxically, confers a patina of neutrality on a majority opinion, laying waste to almost 50 years worth of precedent. It is that it presents the court as the hero, the Knights Templar, if you will, vindicating the historic injustices that Roe and Casey wrought. In this regard, it is unsurprising that the Dobbs majority equated its work with the work of the court in Brown v. Board of Education, which famously overruled Plessy v. Ferguson in order to correct the injustices done to racial minorities during Jim Crow segregation, or the court in West Virginia State Board of Education v. Barnett, which overruled Minersville School District v. Gobitz, in order to correct the injustices done to religious minorities. With this in mind, I think it's Gobides. With this in mind, the majority's pronounced interest in wages, as opposed to democracy and distrust, is perhaps more obviously legible. In wages, Eli's critique of Roe is not limited to the view that the decision is unmoored from constitutional text. In addition to lacking a constitutional foundation, Eli notes, the court's decision in Roe failed to grapple fully with the compelling interest in the protection of the fetus. Having an unwanted child can go a long way toward ruining a woman's life, Eli concedes, but abortion is too much like infanticide on the one hand, and too much like contraception on the other, to leave one comfortable with any answer, and the moral issue it poses as fiendish as any philosopher's hypothetical. On this account, what makes abortion especially vexing is that there are discrete and insular minorities on both sides, women and fetuses. According to Eli, the problem with Roe is that the court prioritizes the interests of only one of these groups. Simply put, Eli in Wages gestures toward the view that the court may have a role to play in mediating the competing interests at stake in abortion, but that a proper understanding of its role would require protecting the fetus, which is perhaps more vulnerable and politically powerless than the women prioritized in Roe. As Eli explains at length, compared with men, very few women sit in our legislators, but no fetuses sit in our legislators. Compared with men, women may constitute such a minority compared with the unborn. They do not. I'm not sure I'd know a discrete and insular minority if I saw one, but confronted with a multiple choice question requiring me to designate A, women, or B, fetuses as one, I'd expect no credit for the former answer. Meaningfully, this account of the fetus as an underrepresented constituency in need of judicial protection can be glimpsed in Dobbs. Throughout the opinion, there are repeated references to the fetus and acknowledgments that some individuals and institutions, including the Mississippi legislature, view the fetus as an unborn human being. Further, the majority's efforts to sequester the court's treatment of Roe and Casey from other substantive due process decisions rests on the distinction that, unlike Roe and Casey, those other decisions did not involve the destruction of potential life. But perhaps most telling on this front is the majority's discussion of abortion's eugenic potential. In a footnote, the majority reiterated a view, husbanded by Justice Thomas, that those who seek liberal access to abortion have been motivated by a desire to suppress the size of the African American population. The Dobbs majority's nod to the abortion as racial genocide argument is, on some level, gratuitous, given that the decision to overrule Roe and Casey rested on the view that the abortion right is unmoored from constitutional text and lacks deep roots in the country's history and traditions. But even if it does not serve a jurisprudential purpose in the Dobbs analysis, the footnote serves an important discursive purpose. It builds the case for viewing limits on abortion as anti-discrimination measures, and more importantly, for viewing fetuses as a minority group. Critically, then, the majority's reliance on wages does more than simply allow the court to reframe its actions in more palatable terms. Obviously, the Dobbs majority's pivot to democracy has considerable rhetorical power, allowing it to reshape the public's understanding of its actions as democracy enhancing, as opposed to a bald exercise of judicial power. But, more profoundly, the invocation of democracy, alongside these other discursive maneuvers, has the broader potential to reshape, however subtly, the understanding of who is in the polity and who the identity of those discrete and insular minorities whom the court is obliged to protect. In this way, the Dobbs majority's allegiance to wages and its relative neglect of democracy and distrust is revealing. By itself, democracy and distrust could cloak the majority in the mantle of democracy, allowing it to portray itself as the hero, even as it performed the arguably unheroic act of withdrawing a fundamental right. Wages, however, not only serves this rhetorical purpose, it goes further, gesturing toward future acts of judicial heroism that build upon the foundation that Dobbs lays. For wages, more so than democracy and distrust, makes clear that the majority's vision of democracy and democratic deliberation on abortion does not end with returning abortion to the states, but with an acknowledgement of the constitutional interests of the unborn. There are hints in the opinion, and elsewhere, that this is afoot. The majority's decision to focus primarily on principles of democracy rather than the illegitimacy of the doctrine of substantive due process may reflect a desire to preserve the possibility of later reliance on substantive due process to justify constitutionalizing a rule that would prohibit all abortions. And the court's repeated references to fetal life, potential life, and unborn human beings may have been designed both to lay the foundations for constitutionalizing such a rule and to broadcast receptivity to such claims to litigants and lower courts. And indeed, some courts have eagerly embraced this fetus forward posture. In Alliance for Hippocratic Medicine v. FDA, a challenge to the Food and Drug Administration's 2000 approval of mifepristone, the first drug in the two-drug medication abortion protocol, Judge Kaczmarek adopted the nomenclature of the anti-abortion advocates, challenging the approval, repeatedly referring to fetuses as unborn humans, babies, and children. While scholars have for many years sounded the alarm on the marshaling of anodyne laws to support fetal endangerment claims, such efforts have intensified in the post-Dobbs landscape. In Texas, Marcus Silva recently filed a wrongful death suit against three women who, he alleges, assisted his estranged wife in securing a medication abortion. Although the Texas Heartbeat Act allows individuals to file suit against those who assist someone in obtaining an abortion, Silva did not avail himself of this litigation avenue. Instead, he chose to file a traditional wrongful death claim to recover for the wrongful death of baby Silva. In addition to the wrongful death claim, Silva further alleges that two of the women conspired with each other to murder baby Silva with abortion pills, and that assisting a self-managed abortion in Texas is also an act of murder. Silva's insistence on filing a tort suit and analogizing medication abortion to an act of murder is meaningful. Under Texas law, wrongful death claims may be brought against anyone who negligently or wrongfully causes the death of an individual, a category that specifically includes an unborn child at every stage of gestation, from fertilization until birth. Likewise, under Texas law, murder is committed when a person intentionally or knowingly causes the death of an individual. In this regard, the resort to traditional tort and criminal law vehicles, which typically are deployed to redress offenses to the person, may be understood as an effort to normalize and embed the view that a fetus is a person, and indeed a person who is vulnerable and in need of the state's protection. Anti-abortion groups make the point explicitly. In social media and media talking points, some of the most prominent pro-life groups in the nation have indicated they are not content to let the citizens of the several states make their own decisions about abortion within their respective jurisdictions. Instead, these groups have made clear that their desired outcome is the recognition of fetal personhood. Taken together, these developments suggest that Dobbs' state-by-state settlement is likely just a way station and not the final destination. Instead, the true potential of the Dobbs majority's vision of democracy, enhancing jurisprudence, likely will be achieved when the rights of an overlooked, discrete, and insular minority, the fetus, are finally recognized, whether through majoritarian politics or judicial fiat. Conclusion. As we have shown, Dobbs cannot be understood to rest on or further principles of democracy. Rather, a careful examination of the intellectual origins of the democratic deliberation argument reveals that Dobbs and its refashioning of the doctrine of stare decisis are products of a set of interconnected legal, movement, and political efforts designed to undermine and ultimately topple Roe and Casey on the grounds that democracy demands that result. But even on its own terms, the court's appeal to democracy fails. Throughout the Dobbs majority's opinion presented an extraordinarily limited, even myopic, conception of democracy, one that misapprehended the processes and institutions that are constitutive of democracy, while also reflecting a distorted vision of political power and representation. The opinion compounded these distortions by refusing to grapple with the anti democratic quality of the interpretive method it deployed to identify fundamental rights that are worthy of judicial protection. Indeed, the majority's adherence to a history and tradition analysis binds constitutional interpretation to a less democratic past in which very few Americans were meaningful participants in the production of law and legal meaning. The cynicism of the Dobbs Court's invocation of democracy is even more pronounced when considered alongside the Court's active interventions to distort and disrupt the functioning of the electoral process. On this account, Dobbs purported to return the abortion question to the people at the precise moment when the court's own actions have ensured that the extant system is unlikely either to produce genuine deliberation or to yield widely desired outcomes. Focusing on these dimensions of the Dobbs majority's discussion of democracy, however, may reveal a more profound and jarring truth about the opinion. Beyond its cramped myopia, the Dobbs majority's vision of democracy and democratic engagement was one that posited the court as a hero, vindicating democratic processes while also vindicating the rights of particular minority groups. While its ostensible focus was the vindication of democratic values, the Dobbs majority can also be viewed as laying the ground for greater protections for the fetus as a discrete and insular minority. Accordingly, the court's democratic deliberation settlement is likely just a way station en route to a final destination, the abolition of legal abortion in the United States. Here, past may be prologue. Just as the initial resistance to Roe sought not to leave abortion to the democratic process, but to end it entirely, Dobbs may represent an intermediate step that aims to shift political dynamics and desensitize the populace to the deprivation of access to legal abortion. For now, legal and political fights around access to abortion will largely be waged in state legislatures, state courts, and state executive branch offices, and through the mechanisms of popular democracy. But it seems all but certain that, despite its broad endorsement of democratic deliberation, the Supreme Court has not spoken its final word on this question. Well, that was a good read. And as always, if there's any case or legal document you'd like me to read, just drop in the comments. We're happy to take a look. Thank you.